Bankruptcy Judge Joseph Meier from Boise, Idaho, wrote a highly thought-provoking opinion regarding limited partnerships. In the case before him, you see, the individual debtor was a limited partner in a partnership that apparently had some considerable value, because as a limited partner, this debtor was entitled to tax distributions each year that could be as much as $50,000. So therefore, one has to assume that the partnership itself, or the limited partner's interest in it, had a very considerable value. In any event, as you know, the Bankruptcy Code requires that a trustee assume or reject an executory contract within 60 days, otherwise it is automatically rejected. So, you guessed it, after the 60 days, the trustee requested a tax distribution. And as you also are guessing, the limited partnership said no. It was automatically rejected. That imposed upon Judge Meier the responsibility for deciding whether or not it was, in fact, an executory contract. Judge Meier employed the so-called countryman definition of executory contracts and decided that no, it was not executory, because the debtor, the limited partner, only had options, and failing to exercise those options was not a material breach. Now here's where it gets interesting. On the other side of the street, Professor Jay Westbrook from the University of Texas Law School in Austin has the competing definition of executory contracts, explained, among other places, in his seminal article in the ABI Law Journal in 2017. Employing the analysis by Professor Westbrook, I have to conclude that it would have been or was an executory contract. As we sit here right now, this whole question regarding limited partnerships is very much up in the air. Some courts say yes, some say no. Some courts even say it's not a contract at all. It's just basically an asset to be treated under Section 541. Well, I tell you what, this is an issue I doubt that's going to be resolved anytime soon by the courts, and it may never reach the U.S. Supreme Court. But for the time being, have a look at my article on this opinion, which appears in my column on the ABI website on Thursday, March 16. I am Bill Rochelle, the Editor-at-Large for American Bankruptcy Institute. I shall return same time next week with something interesting about bankruptcy. Until then, be well, stay safe, and good day.